Thank you, Mr. Speaker. This is the 15th time this so-called temporary act in its various forms has come before Parliament or its predecessor for the renewal of another 5 years from 21st October 2024. This law puts people behind bars or restricts their movement at the order of the Home Affairs Minister. Like the Internal Security Act, it is a controversial exception to our legal justice system, which usually requires every person to be charged, tried, and convicted in court before he is imprisoned or fined for his wrongdoing. Under this act, the minister can, with the consent of the public prosecutor, order the detention of a person for any period not exceeding 12 months if the minister is satisfied that it is necessary that a person be detained in the interest of public safety, peace, and good order. The minister can also make an order for a person to be subject to the supervision of the police for any period not exceeding 3 years if he is satisfied that it is so necessary. Every order shall be referred to an advisory committee which shall submit its recommendation on the order to the President, who has the power to confirm, cancel, or vary the order given. Taking away someone's liberty either by detention or by restriction of movements and activities should not be taken lightly, as the impact on liberty and freedom. Time limits for detention and supervision should also be viewed from the perspective that each order can be reviewed annually with the agreement of the President and at the recommendation of an advisory committee and on the advice of the Cabinet. Mr. Speaker, in past renewals of the Act, there were members who have spoken up about their concerns about the undesirable aspects of the Act and have asked the government when we can finally do away with this Act. I'm glad that we are here today to debate the extension of the Act for another 5 years, and not more than that. In the past, some members have even suggested that the bill should not be a temporary one, but should be converted to a permanent one. I certainly cannot agree with that. Many members have, over the years, also spoken in agreement with the Minister of the Day on variously the rationale for extending the Act to deal with the concerned crimes or criminal groups of the day. I read from ministers and MPs' speeches in the Hansard that this range from secret societies, gangsterism, drug trafficking, murders, extortion and protection rackets, to, in more recent years, money laundering, loan shark syndicates, organized crimes, and global match fixing. There was also mention of arguably activities which are traditionally not regarded as criminal, such as prevention of strikes and lockouts, as well as communist domination. The MOS has also highlighted some of the recent serious cases in the past 5 years which required enforcement under CLTPA. I'd like to ask the MOS of the types of cases highlighted, what is the number of detention and supervision orders granted for such type of crimes over the total number of all CLTPA orders in the last 5 years? I'd also like to ask the MOS, in the last 5 years since October 2019, what is the total number of people who, 1, have been detained under the CLTPA, and 2, have been subject to police supervision under the CLTPA? Can the MOS give a breakdown of the number of persons subject to CLTPA orders organized according to the different category of criminal activities? Can the MOS tell the House, this House, of the persons who have been detained in the course of the last 5 years, what is the proportion of detainees who have served more than 2 years? And how many of the current detainees have been in detention for more than 5 and 10 years, respectively? I also like to ask the MOS in the past 5 years whether there have been instances when the public prosecutor actually withheld consent or raised concerns when the minister sought to make an order. Mr. Speaker, the Workers' Party objected to some of the amendments which the government sought to introduce in 2018, together with a 5-year extension from 2019 to 2024. Among other things, in 2018, the Workers' Party had expressed concern with the finality clause in the amended Section 30 of the present Act under the then Clause 3 of the Amendment Bill, which made the decisions of the Minister on detention and supervision to be final, the insertion of the 4th schedule, which may allow ministers to bypass answering questions such as whether a case is serious enough to justify detention, or why it is not possible to prosecute these persons in court, and also expanding the minister's powers to police criminal activities overseas. In today's second reading, the government is asking for a 5-year extension of the Act, and no amendment of the current Act is being proposed. I confirm that the Workers' Party objections and reservations to some of the amendments raised in 2018 remain. However, we are in cautious support for the proposed 5-year extension today, subject to the government's explanation for the authorities' use of the CLTPA in the past 5 years and justifications for an extension of a further 5 years. Mr. Speaker, as the Honourable Ms. Sylvia Lim had articulated in the 2018 debate about the Workers' Party's support for renewals of the Act prior to 2018, the Workers' Party she said that the Workers' Party has accepted the uncomfortable compromise that this law entails on the constitutional rights to freedom, and that we did not delight in taking such a position, but did so with a heavy heart. Mr. Speaker, in 2018, the Minister, in justifying for an extension of the Act in the second reading speech, raised examples of CLTPA being used against gangs, unlicensed moneylenders, drug syndicates, and global match-fixing syndicates in the years before that. He mentioned of victims being unwilling or unable to identify attackers. He also mentioned of victims or drug couriers unwilling to testify in court for fear of reprisals. The Minister also mentioned that while the drug situation was under control, the challenges had remained significant. In MHS press release dated 7 March 2024, in respect of the first reading of today's bill, it was stated that the Act is, I quote, an essential legal instrument for the police so that they can act effectively against secret societies and criminal syndicates, such as money lending and drug trafficking syndicates, where prosecution is not viable because witnesses are unwilling to testify in open court for fear of reprisal. MHA stated that since 2019, the Act has been used to detain or place under supervision persons heavily involved in secret society activities and leaders of organized crime syndicates such as an overseas licensed money lending syndicate. The same release also provided 4 recent cases of CLTPA recent enforcement, all involving gangs and witnesses refusing to give evidence for fear of reprisal. The MOS has also briefly touched on this in his speech. Indeed, the scenario shared by the Minister then and the MOS today are not new, and CLTPA has been used in such cases relating to crime and drug syndicates and gangs for a long time, and they would often involve fear of witnesses testifying in court for fear of reprisals. Looking at the explanations given in the cases mentioned by the ministers in recent second reading speeches, I do wonder whether the government will require further extensions of the Act as long as criminal activities such as gangs, drug and crime syndicates, unlicensed money lending, etc., continue to persist, especially coupled with possible intimidation of witnesses. I'd like to ask whether MHS has also looked at other crime control or enforcement methods or models to deal with the specified criminal activities of gangs, drugs, and crime syndicates and unlicensed money lending, and to work around witness intimidation issues. How has SPF utilized the technological advances and deployment of technology in the police force? For example, use of cameras at an unprecedented scale these days to keep these crimes problems under control. Indeed, with the increased use of technology by our SPF and also the development of SPF over the years, will advances in our policing methods as well as technological advances help to control the age-old problems of gangs and crime syndicates and mitigate against the age-old problem of witnesses not coming forth to testify? Mr. Speaker, even as the crime situation in Singapore may have been evolving and still does, it is difficult to deny that we have come very far in our crime situation since almost 70 years ago when this temporary act was first introduced. In recent years, we have also received assurances from Minister that the number of detainees under the CLTPA have been declining. As we review the need for a renewal of the CLTPA today, for the next 5 years. I would therefore like to ask the MOS what would be the conditions or goals, the attainment of which may grant confidence to our government to consider not seeking further extensions in future. Over time, other MPs have also asked the question essentially of when we will be ready to do away with the Act. The current Minister of Home Affairs has asked a similar question even back in 1989. The then Home Affairs Ministers answered as follows, and I quote, Mr. Shanmugam asked, when can we do away with it? My answer to that would be, we can do away with it when we are satisfied that both the secret society component of our objective and the drug traffic component of our objective are reduced to such small proportions that we can safely say that we do not need this to control both aspects. The minister then went on to elaborate on his views. Almost 35 years on, I look forward to the current minister's answer and update. Mr. Speaker, subject to the replies to the questions and clarifications to my queries and concerns, the Workers' Party support the extension of the Act.